Okay, so I guess everyone else is here for this bill. Everyone is interested in this, so we'll just move right in. Ms. Brown.
CV5, 2016. In accordance with state law, this legislation amends the zoning ordinance to define terms related to state licensed medical cannabis uses, permit state licensed medical cannabis growing or processing facilities by special exception in the CSC, CO, I1, I2, and OS zones under certain circumstances, and permits dispensary facilities in certain commercial, industrial, and open space zones, as well as statutory limitations or conditions for the location of a medical cannabis facility within the county. Planning board took no position on the legislation. However, they did provide a staff analysis that's attached to their letter that Ms. Hightower could provide details about the Office of Law, as well as the zoning hearing examiner provided comments. And since they're at the table, I'm sure they'll explain their concerns. And there was also correspondence received through Councilmember Glaros from Capiston, representing Beltway Plaza Mall, requesting the committee to reconsider the zoning and distance requirements for the dispensary proposed in legislation. And that's all I have.
Thank you. And so what I will say to this is that the state of Maryland passed legislation that indicated that in every senatorial district, medical cannabis facilities could be placed. And 2 in each senatorial district. And in order to ensure that we do our due diligence as electeds here in Prince George's County who have zoning authority, we put in this piece of legislation to try and keep basically the state from saying where facilities will go in our communities. We know our communities better, we know our residents better, and we believe that it is our responsibility to do the best by them. And so that's how this particular piece of legislation came about. As I said, we're not going to take any action on it today. I'm certain that there will be some amendments somewhere along the way. What they are, I don't know, but we'll certainly hear about that. And so that is the impetus for this legislation, the starting point, and we'll see where and when and where we end up with that. So with that, I'll turn to Ms. Hightower.
Good afternoon, Madam Chair.
Good afternoon.
Again, some of the planning board comments, I'll just go through a few bullets that are already in your letter.
Mm-hmm.
The definitions seem to be incomplete. They don't seem to match the state's definitions for some of the uses that are listed in this bill. Also, the terms need to be clarified that are in the bill. Many of the operational aspects of the bill are already preempted by the state, i.e. the state outlines what should be done regarding operations. And lastly, the bill doesn't seem to address any zoning requirements like landscaping, building setbacks, parking and loading standards. Those are some of the few things that the planning board wanted you all to know about and to consider.
Okay, let me step back one more time though on this. This was I'm going to call it a collaboration of 2 bills that were started. I had originally put in a bill draft last year, to get started on on a piece of legislation that essentially mirrors what some of our neighboring jurisdictions had. A couple of my colleagues were also working on something, and as I understand it, was working with planning staff, which is actually where the majority of this bill came from, the way that I understood it. I'll put it that way. And so, if that's not the case, then I apologize that I misunderstood, but that's the way it was told to me. So then with that, we certainly will not move forward, and we will work with you, because we want to do as closely as the state has prescribed. We don't want to give any more, quite honestly, because the majority of our residents don't want it. But we are bound by law, in quotes. And so, with that, we accept what you say, and we'll have to work through that. I'd like to turn to Ms. McNeil, please.
As to the latter issue about standards, zoning standards, I did note that in other special exceptions, we have language that makes it clear that whatever's approved on a special exception site plan are the standards. So that would, if we're an easier way to fix this, I thought we could mirror, for example, it's in 27337 with apartment housing. So I did agree that there needs to be some reference to standards. On the preemption issue, you all have heard from lawyers from time to time. It's not as clear an area. If the state says you can't do it, clearly you're preempted. If the state has regulated thoroughly, you may be preempted because it's an implied preemption. And then if there's a conflict between what the state said and what you're saying, there's a preemption. So the issue about the lighting and the security is the gray, because the state seems to have done a lot about that. So, but it's a gray area. But the issue about it has to be within, the growing of it has to be within a facility. They do have a section in the state law talking about what happens when you want to grow outside. So that's why I mentioned that. That could be a conflict, because they're saying it can be both ways. And since you're making it a special exception, the people can come to you and explain why, and then you can agree or not. You know, you're giving them the opportunity to come with their entire package and convince you. I'm trying to rush, if I know you
Don't rush,
So,
because I think this is our last,
the issue about the definitions, it's just that it's easier to just mirror them, because if they change them, then we don't have to worry that we missed something. The issue about the doctor's offices, I get that with the dispensary, but I'm wondering, do you want the same language with growing? And maybe you do, it's just that we would have to beef up in the record more about where I grow it needs to be near a doctor's office. See, we have 3 different special exceptions here, and we're sort of mirroring the same language in all 3, but they're different things. I just throw that out. That's good.
I appreciate that.
What, it being it?
I appreciate your comments, I appreciate your comments. Ms. Abankas?
At the ready to collaborate and get the best technology.
Mr. Gwen?
Thank you. I'll reiterate the concerns about mirroring the definitions with the state. Also, I guess the comment concerning a doctor's office versus, I guess, a other specialist office that needs to kind of be explained more clearer. Also, something that wasn't addressed, I think the bill on page 10, lines 4 through 5, requires that deposits, the payments be made in a vault, a secured vault.
Mm-hmm.
There has to be, the concern from the Office of Law is that there's no nexus to zoning and planning for that requirement.
Isn't that in page 10, lines 10 through 12? Isn't that in state, that's not in state law?
That's not in the state regulations.
Okay.
And so, I guess maybe to get there, maybe something that would be locational is requiring that each facility has a secure vault, but I guess the bill as drafted speaks more to the operational side of
And so you don't consider, the dealing with because it's a cash business, you don't consider that to be operational?
Well, the bill is drafted, it says that it requires the payments to be in, so I'm saying, maybe you can say that the facility should have a vault, instead of just saying it should be deposited, I guess, multiple times during the day. So it's just a,
But you don't consider that to be operational? I
No.
consider that to be operational.
it is operational.
Okay, so Ms. Zavankis?
Sure, could we do something like we did with the video, the casino legislation, wherein maybe the folks coming in need to submit as part of their materials a security plan that the chief reviews. Maybe that way we're not getting so granular about it, but at least we're covering our bases in terms of ensuring that there's appropriate controls in place for public safety purposes. If that would, I just thought back to that when that bill was done.
Mr. Nguyen, does that satisfy your concern?
As long as it has a nexus with zoning and planning, then I think there's ways to get to where you want to get to.
Madam Chair, I'm sorry. I could possibly clarify this a little bit more for you. I'm Debra Borden with Park and Planning. The state COMA regs require a security plan to be submitted with the application, and they require a vault for the storage of the product, for the storage of marijuana. The language doesn't say anything about storing money or cash in the vault. It does say that these facilities must have a secure vault, and there are specifications for that, but it talks about the vault being for the storage of marijuana. That doesn't mean that money can't be stored there, but that's what it says. So there's a little bit of disconnect, but there is a requirement for security plan to be submitted with the application. And so again, the question that Maureen raised, have they covered everything such that you can't avoid conflicting with them by adding another requirement? Because then if you add something that conflicts with the security plan that they've approved, that the state has approved, aren't you then in conflict? So that's a question. I mean, we can tease that out a little bit, we can talk to the state about that, but I would suggest talking to them to see where they see any gaps in that, to see where you should maybe plug the holes, because you don't want to put a regulation in that's just not going to be able to be enforced.
All right, so Ms. Zavankis, you have that with, as far as it's that level of a possible amendment.
Yeah, I think there's some room in there. We can really tease it out and see, which is exactly how far. Again, as I recall, the video monitoring terminal legislation, there was a similar requirement in the state government article that required certain security measures be submitted as part of their application for a license for the table games and whatnot. And we in turn did our own that the chief would review. So I think there's probably some room there. We certainly will be mindful of what's going on and not conflict with what the state is doing, so as not to frustrate what has been permitted or declared permitted by the state. So we can go back to the table and craft something that would work.
Okay, thank you. So I'll turn to my colleagues, starting with Mr. Harris.
Thank you, Madam Chair. I'll start with saying that I have a lot of grave concerns with the current bill, because I feel that it's treating dispensaries as if they were a liquor store, an adult, adult bookstore or something of the like, or even if that was not intended, I think that we're creating a scenario where that is eventually going to happen. And so I'm concerned really that we really need to have a clearer vision of where we would like these dispensaries to be located. And I preferably, while I understand, Madam Chair, that you say that overwhelming a lot of people don't want it in the county, my district is thirsty for it. They definitely want it, and so does the district. And the bill as currently drafted
has no sites within District 2 or 3. And so, I mean, that's a problem. And so I've really thought about this hard, and I hope that we can have more conversations about this, because I think that a dispensary in an industrial zone, to me, is a danger waiting to happen. It doesn't make any sense to me. On the other side, not including MXT on the other end is also doesn't make any sense. And I agree that we may not want it in areas that are like Woodmore, where they're isolated. I think that the way to get around that is by having a half a mile or a mile's 500 feet or 1,000 feet away from rail lines, and you can control that by through that. And I've looked at maps that look like, and I want to be able to share that with you to show that it creates a nice dispersed area. I think that there's a fear that there's going to be a high concentration of these facilities in the county, and I don't think it's a fear that's really based on reality, because we have to recognize that a lot of these processors and growers have to be dispersed throughout the entire state, as well as these dispensaries. They cannot be concentrated. So I think that that there is some changes that we can work with in terms of adding an MXT zone, limiting dispensaries to outside of industrial zones. And I think we need to age the commercial shopping centers, because we don't want shopping centers that are old, neglected. I mean, I know shopping centers in my district where I wouldn't want to see this there. I don't want to see this in an area where it's ridden for crime. And so I think we need to age these locations in nice upscale area where there's walkability, where it's a growing area, where there's activity happening, and it's a thriving area that we want to focus our energies on. And so because that helps with the basically the economic engine of rejuvenating an area. And so and that's the kind of upscale area we want to place these in, by and near a medical facility, by a legal doctor that can issue a prescription. And if we do it like we do a Foggy Bottom, where you have the hospital there, you have your x-ray facilities there, you have your medical clinics there, you have your pharmacies there, that's the kind of environment we want to be able to create around these dispensaries. Having a medical facility, a pharmacy, a medical doctor, those are the kind of areas we want to see it in, as well as an upcoming upscale area. So that's the vision I have for where these dispensaries need to be. And I'll leave to my other rural colleagues to handle the rural piece. But in terms of where these dispensaries should be, I'm okay with looking at the vehicle artillery, but I'm very concerned that these are not near any metro rail stations. And I'm concerned that MXT is not included here. And I don't think that, given the density of my district, to have it near any dwelling units at all doesn't make any sense whatsoever. So I am respectful of having residential zones still respected, like communities are R55 and such. I'm very respectful of that, but to have it near any dwelling doesn't make any sense. So I have some comments that I've drafted up. I'm willing to share it over the next couple of weeks with everyone. And but I really want to just urge you to really have a clear vision of where we want these things to be. We don't want them hiding in the shadows and being adult nightclubs the way we're treating adult nightclubs. We don't want that there, because that is a danger waiting to happen. We really want these in prominent, safe areas. Thank you.
Thank you. Let's see, Mr. Franklin was queued up. Do you want to?
No.
Okay. Anyone else? All right, we have signed up to speak Matthew, and I think it's Gorman.
Yes.
Okay.
right here is fine. Thank you.
And you just hit the button on there on this mic and you have 3 minutes.
Thank you, Madam Chairwoman, and council members. I'm here on behalf of a number of dispensary applicants. And we are very concerned about the legislation. And I think our research also shows that certain districts won't have any sites that would work given this legislation. And in particular, I think, you know, I hope this council looks at what the goal is in terms of what problems they're trying to solve. If it's a public safety issue, if it's an issue of being too close to schools. Certainly we don't want these dispensaries too close to schools. But it appears to me that this legislation seems to incorporate the federal drug-free zone legislation as its driving force with the 1,000 feet from a dwelling unit, residential property, place of worship, public park, public recreation. I just hope the council realizes that that federal drug-free zone regulation is in a sentencing enhancement regulation saying if you have illegal activity, drugs or guns in these particular zones, you are subject to enhanced sentencing. The state has said in their legislation that this is legal activity and they would like to have it in the state as it offers benefits, medical benefits, to the citizens of Maryland and hopefully, you know, to the citizens of Prince George's County. I think that this should be treated as any other either pharmacy or medical place, subject to, I agree, the 1,000 foot away from schools or churches to mirror what's been done with alcoholic beverage regulations. I agree with the councilwoman that to overly regulate this and to place it in places that are out of the way in industrial zones stigmatizes those who could benefit from this in terms of receiving medical care that they need. In addition, what we're talking about here is not primary care, right? You're not going to a hospital to ask for a prescription for medical marijuana. This is more maintenance, this is secondary care, this is treatment of debilitating illnesses, pain relief, and these are things that I don't think require a hospital. 3 minutes up? All right, thank you.
Thank you, Mr. Gorman, we appreciate it, and we got the gist of what you were saying, so we appreciate you coming in.
If I may, for the record, if I could just submit, I have a study here. It's a study outlining the,
Is it,
okay.
do you need copies? I mean,
If I
that
just
whole
have it
thing-
submitted into the record.
Okay, that's fine, if you
All right.
just give it to the clerk,
All right,
then make sure we get it.
Thank you.
Thank you.
Thank you.
All right, thank you. Do we have any other comments on this? Anyone want to say anything before we close out?
Oh, one more thing.
Mr. Veras?
That, just a quick reminder that the processors and growers are the super licenses, so by de facto, they're already dispensaries. So we don't need to duplicate that in industrial zones. And so, again, so that's the only other, and I was concerned with why we have dispensaries in open space zones. I'm concerned about that. I think that's a
That's what I read.
I don't want these facilities to be a sitting duck for dangerous criminal activity and to be accosted in any way. So I'm concerned about that, and so I think that they should be, like I said, again, in thriving areas where there's activity, where there's people walking, where we wanna see, you know, a rebirth, so to speak. So those are the two critical issues that I'm just want to bring to the table. Thank you.
Thank you.
And
Ms. Brown?
there was one additional comment that's in your backup I neglected to mention from the City of College Park staff. It wasn't the city's position, but just their staff comments from Bill Gardner. Have it on your backup.
Okay, thank you. Ms. Toles?
I had a question in terms of, I don't know, maybe something we look at later, but how minorities will be able to, operate dispensaries in the county. Do we have, based on our particular county laws, or is that regulated by the state?
It's encouraged in the state laws that would be minority individuals getting these licenses, and then minority individuals will have access to the medicine.
Drugs, what they are, I don't know why anybody want them in their community. I certainly don't want it in mine. I'm gonna state that for the record right now, so Mr. Barris can have my dispensaries.
I don't want them. I got two.
No, you said you didn't get any.
Oh, well, yeah. Well, this is.
So you can have some now. And I know we're gonna hear this again, so I don't wanna take up too much time. And, we'll work with our talented team of attorneys and staff members that we have here who, on the council's end, to make sure, and I'm gonna state that for the record, that the council, at least I am, I can't control any of what my other council members wanna do, work with making sure that we are in the parameters of what the state allows us to do and gives us the authority not to do. So, and planning board can work around that. The council is hired by the people in their community to put in policies and legislation and laws that protect them and improve their quality of life. And they hire me to do a job. And if I feel like this does not improve their quality of life, I'm going to find a way within this law to make sure that I don't do anything to put down their quality of life. And I want everybody here, planning board included. I'm done.
Thank you. Thank you, Ms. Toles. Ms. Brown, do we have any other business?
Ma'am?
All right, so then we will, our next meeting will be on March the 16th at 2:30. We will hear CB7, and then we will go right into park and plan and budget. So our first here at park and plan and budget, 16th. The day of the Women's History Month luncheon. That, and we